Reed thing. And now that I have the time, I'm gonna go ahead and give y'all this Karen Reed update and get on out of y'all's way. And shout out to I Don't Belong Here with Samantha Beningo. Anyways, the name of the channel is called I Don't Belong Here. Let's get into it.
If you're running a small to mid-sized screen printing shop with a hole thrust tube explosion system, upgrading to an LED explosion.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. No
Worst
speculations,
prosecutor
lies,
ever.
conjecture. Stay true to the evidence. It will lead you to the truth.
For once in my life, Hank Brennan and I completely agree.
God save the Commonwealth of Massachusetts.
Welcome, welcome, welcome. This is the I Don't Belong Here show, and I am your host, Samantha Beningo. I am a behavioral scientist, a career psychotherapist, a sixth-year PhD candidate in clinical psychology, a master's level psychologist and counselor, and today we return to Canton, Massachusetts to seek justice for Boston police officer John O'Keefe. Boy, is this case the case that just keeps on giving, as once again, the Commonwealth of Massachusetts looks to try to indict, you guessed it, Karen Reed.
During the trial, jurors heard expert witnesses testify about data taken from the car's computers.
There's actually many, depending on the vehicle, there could be hundreds.
And investigators say they had to damage the Lexus to extract the airbag and infotainment system data.
2 photographs during the disassembly process of taking that module apart.
The owner here at the shop hopes to have his work done within a week.
It's going to cost her nothing. It's probably going to cost me a couple $1,000, but more than happy to do it.
One of Reed's lawyers says the defendant, who was only convicted of drunk driving, is relieved to get some of her property back.
I think very thrilled and excited to just have one more piece put to rest.
But Reed is still missing 2 cell phones. Her lawyer says they're not being returned because the Norfolk County DA is investigating her for intimidating witnesses in the case. Steve Buzak says the DA brought the case before a grand jury but failed to get an indictment. He believes prosecutors are planning to try with a different grand jury.
The facts are not there, so I don't know why they want to go back. I'm not sure. But we'll find it out in court.
And as I have been digging through these receipts, these trial receipts, and most people have been focused on the egregious $1.4 million and counting price tag.
Second Karen Reed trial is being dubbed the most expensive OUI prosecution in Massachusetts history.
Well, Priscilla, it's clear Norfolk District Attorney Michael Morrissey put his chips on the table and decided to go all in. When looking at just the cost of the expert witnesses hired by the Commonwealth, the second trial was nearly 20 times more expensive compared to the first.
That the Commonwealth spent on Karen Reed's OUI, I have been busy digging through the Aperture receipts, and because of Aperture's propensity for keeping pretty detailed records, boy, do they tell a story. Today we're going to take a look at, first, how it is that these receipts prove, number 1, the Commonwealth was knowingly persecuting an innocent woman. Number 2, that Aperture also was knowingly persecuting an innocent woman, and while doing so, committing perjury while under oath. And number 3, how it is that we now know 100% why it is that the Commonwealth will not and cannot ever admit defeat in this case. How it is that they have to continue to put up the front that Karen Reed is guilty, otherwise it directly indicts them. I finally understand that this case is truly about survival for the Norfolk County DA's office. And that is the reason why they just keep doubling down and doubling down.
Yep.
And more so than ever, what I would say to you is what I'm going to show you is so disturbing and speaks to what happens when the most incompetent, inept, outright stupid, unqualified human beings
Dang.
get their hand on
She is
unimaginable
going in
power
on their
and
ass.
authority, and that we've got to do something about it, because people like this that are morally bankrupt and unwilling and unable to actually tell the truth, who are interested only in self-preservation, and who are
Facts.
fundamentally incapable of seeking justice on behalf of the people that they swear an oath to protect and serve. Now, what I'm going to show you gets tedious. It'll make you want to just glaze over and stop paying attention. But I cannot stress to you enough how important it is to just listen and try to keep up. Because in this case, the devil truly is in the details. Let's get started.
Here
Now,
we
one
go.
of the real tragedies in this case is how the O'Keefe family has, from the beginning, determined that Karen Read was guilty of this crime based on the way she behaved in the first few hours after learning of John O'Keefe's death. And sadly, because of that, they have been incredibly vulnerable to manipulation, both on the part of the McAlberts, but more importantly, and more tragically, on the part of the prosecution, who have played them like a violin and who have claimed that they're doing this, that this big persecution of Karen Read is on behalf of the O'Keefe family. And because of that, these people who I think are probably very good human beings and who really do want to see justice for their loved one have been tragically misguided. And in addition to just believing that Karen Read was acting funny the morning after John was murdered, they have also been duped by Hank Brennan, Adam Lally, Laura McLaughlin, into believing that somehow the data, the car data in this case, was an indictment on Karen Read.
To us, the prosecution put on a good case, and to us, that data from her car and from Johnny's cell phone told the whole story. From her car and from Johnny's cell phone told the whole story.
And this is why I have to warn you, we're going to have to dig into really boring stuff for me to show you just how ridiculous, how silly, how misguided, and almost unbelievable it is that the Commonwealth actually tried to pull this over on all of us. Because really, they must think that we are fundamentally brain dead in order to believe what they were trying to put forth.
Exactly.
It was 100.
Your roommate just took up percussion. You need a job that gets you out of here. I need Indeed. Indeed you do.
100% smoke and mirrors, and almost unimaginably, like, it's unimaginable that the theory that the Commonwealth took and ran with and then sold or tried to
I'll
sell
be back in a second,
to
y'all.
all of
Hold
us
on.
was put forth originally by this guy.
Degrees in the scientific discipline of physics.
I do not.
How many degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
The highest degree that you do hold, sir.
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
Multiple classes.
There's the idea of what kinematics is, right?
Correct.
Testified about that on Friday.
Yes.
Define kinematics.
It deals with the aspect of motion.
It's a subfield of what? A broader field.
Kinematics.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
In physics, correct?
Yes.
And it describes how points and objects, systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with the motions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity.
Right.
I mean, it deals with the
Well, in that
motion,
case,
deals
you
with
better be
forward,
careful with the orange
and also
too.
deals with speed, deals with travel and speed.
In what way does that differentiation of 2.5 pounds or approximately 2.5 pounds, in what way does that make a difference in terms of your testing?
It doesn't, and that's part of the reason why we increase the speeds to almost 30 miles an hour to look at, again, when you're bringing that much more kinetic energy. Like I said, if it's a pound difference, 2 pound difference, the momentum of that vehicle moving at 30 miles an hour versus 24 miles an hour, again, kinetic energy is equal to 1/2 times the mass times the velocity squared. So even if you go up a few miles per hour, you're exponentially increasing that amount of kinetic energy from the vehicle. As you saw throughout the PowerPoint, when that vehicle is coming in at 24 miles an hour, 29 miles an hour, at those speeds, that arm, when it makes contact, is going to get accelerated up to that velocity. It's just going to reach that common velocity. It's not going to, you're not going to somehow affect the vehicle speed due to that, the fact that the arm weighing 10 pounds roughly, and you've got 6,000 pounds. It's not going to somehow scrub off speed of the vehicle.
Now, after the first Karen Reed trial ended in a mistrial, Michael Morrissey and the DA's office of Norfolk County
I'm
doubled
still here,
down.
y'all.
They put all of their money, all of the taxpayer money, to the tune of well over, in the end, $1.4 million into trying to convict Karen Reed. And one of the first moves they make, in addition to hiring a defense attorney, Hank Brennan, to come over to the prosecutor's office, was to hire the accident reconstructionist team called Aperture. Now, Aperture was a friendly face to them, and we learned from Mike Morrissey's email dump from his personal server that the reason they went with Aperture is because a former Massachusetts State Police officer, a friend to them, had sold his accident reconstructionist company to Judson Welcher. So this, they knew, would be a company that they could trust to do their bidding. Now, the first contract is signed on September 10th by Judson Welcher for $75,000. And Aperture gets right to work. At one point, they have about 6 people working virtually around the clock. They purport themselves to be working on holidays like Christmas and New Year's Eve, right? I mean, they're just working around the clock, and they've got a whole team, as I said, upwards to 6 people working on this case at any given time. Now, in the end, the 2 that they picked to put forth in front of us is the owner, essentially, of Aperture, Judson Welcher, and their infotainment, quote, expert, Shannon Burgess. Now, we're going to get to them in just a minute. But during the trial, you know, if you were watching carefully, that the... I'm sorry. All right. So from the beginning, Trooper Joseph Paul puts forth the idea that Karen Reed backs into John O'Keefe at 24 miles per hour for 64 approximately feet. Now, the reason that he comes to this conclusion is because I think he says at one point he had recently taken a class in telematics or car data computer systems in accident reconstruction, discovered that sometime around or in close proximity to when they began their testing on the vehicle, that they discovered there was this weird, what's called a trigger event, where the car registers unusual activity is taking place in the vehicle. Now, I'm going to let the experts in this case explain to you very briefly what exactly we're talking about so that it's clear the rest of the way.
When an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording, and as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary, it can be more or less than 5. The specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
This is the tech stream. So it's from Toyota. So the tech stream data. You can see the screens here. There's generally 2 types of files. What's called a vehicle control history and a PCS file. The tech stream system was originally designed, according to Toyota, for maintenance issues. It seemed to come about around the same time Toyota was having problems with sudden accelerations or allegations of sudden accelerations. So the tech stream data or vehicle control history will give you information when there's, for example, excessive acceleration or rapid shifting of the vehicles or rapid steering of the steering wheel. So the statements are that that's designed to help the maintenance people, if you come in with a problem with your vehicle, to diagnose what that problem is.
Now, these problems, when they show up in the vehicle control history, they are called trigger events. Okay? So they are
Okay, what does that
extreme
mean?
Trigger events. Events that were triggered by some unusual activity in the vehicle.
It has a lot of utility.
Okay, what is the unusual activity?
Jam on the brakes before a crash, frequently the tech stream data will record the crash.
So these trigger events are kept track of via key cycles. That is, every single time a new car is turned on and off, that's a key cycle. And it's through these key cycles that these trigger events are kept track of. In other words, any particular driving event, or not even driving event, but just any time that the car is turned on and turned off. The power in the car is turned on and turned off. And the problem with these key cycles is there's no inherent place and time associated with them. There's just a running clock. So the problem that the Commonwealth has is they have to try to sync up this running clock with a real clock, or some way to place the Lexus in front of 34 Fairview. This is a very serious challenge. The way that Trooper Paul reasoned it, there was this 3-point turn. Karen Reed admits to a 3-point turn, and therefore, even though the key cycles do not add up, this must be Karen Reed driving the Lexus.
We did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lappin, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it? Correct. It just shows you when a vehicle is turned on, the ignition is on, and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, Well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't.
What's the
have to be an
difference?
Ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycles is turning accessories on.
All right. But it doesn't. My question was, when we started this conversation, is it does not have any location data on it whatsoever.
Correct.
All right.
Trooper Paul is so stupid and so unfamiliar with telematics that he doesn't quite yet understand what a key cycle means. He doesn't quite understand that a key cycle can also include an ignition cycle.
So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get your location turned off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text string. That's how they read them. Key cycles.
Like key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
It doesn't have to be on.
So just to be 100% clear about what's happening here is that even though Trooper Paul is making the claim that these trigger events happened while the car engine was on, he can't understand that the key cycle must include an ignition cycle.
Idiot.
That is, until Alan Jackson points it out.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, I'm trying to be tricky here. If you're seeing triggering events, if your car's in motion, what does that tell you? The ignition's on or off?
The ignition's on.
Right. That's what it means. It has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not going to report the difference to you, correct?
On the key cycle,
Right.
Just the key cycle. The key cycle does not give out locations.
And say that again?
The key cycle does not give a location.
Right. So your analysis.
So the key cycle don't mean
is to go from a
anything.
known key cycle that you can figure out, and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle. Correct?
I can't use the key cycle to put it back.
Say that again.
I do not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
He never stops to ask, do we have any sense of where the car has been in between 34 Fairview and when I started my testing?
You stated in your report that there were two triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and the key cycle 1164. Is that right?
Yes.
Okay. So what you're saying in that report is the triggering events were 1162 going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
And you knew, you put in your report, or you know, that the triggering events that you see of the 1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were two key cycles before that.
Yes.
meaning ignition cycles at least, right?
Yes, there were 2 key cycles. That.
Stated in your report, well, let me finish one other point. You said that the mileage difference between these 2 triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in the report in paragraph 23, 24, 26, and 29, and also in this exhibit in your car's report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your car's report, I think you mentioned Trooper Zach Clark, is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
You'll notice that moron Trooper Paul tries to distance himself from Sean Good from Canton PD being involved because remember, they're recused.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So starting at 1164 and coming back, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded key cycle at that time.
Trooper Paul is so stupid that he just figures if the key cycles are off, it must be because the car didn't fire the key cycle. Duh.
I
can't speak to the fact that would record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing. Well, I can't speak to how.
I'm here. I'm just
why
aiding.
it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
This is me interrupting your programming to remind you to like this video. Like the video. Yeah, so about those 36 miles. So what Trooper Paul is suggesting is that in between the key cycle 1162, when this alleged backing event happened, and when he began his testing, there were 2 ignition events, 2 drive events, that would have totaled 36 miles. The only pesky problem with this idea is that if we look at where this car had been prior to when Trooper Paul begins his testing, the idea that what our eyes tell us is true simply isn't possible. In other words, if we're working our way backwards, key cycle 1163 would have to be when the car is driven off of the tow truck bed and into the Sally Port, and key cycle 1162 would have to be when the car
I'm still here,
is
y'all. I
launched
was
the tow
eating.
truck when they confiscate Karen Banks' Lexus. But in actuality, there's a driving event missing. And as far as anybody could tell, that event would have had to have been when the Massachusetts State Police had already taken custody of the vehicle. In between, when they took custody and whenever Trooper Paul began his testing. And like the moron that he is, He never stopped for a second to ask, where has this car been? He just assumed, well, who cares about the details? It's close enough. And it's pretty despicable, and it says a lot about Aperture, that after spending months digging through all of the evidence in this case, that they were willing to embarrass themselves by adopting Trooper Paul's theory as their own. I have to tell you that as a scientist, with all that I have being my reputation,
I'll be right back, y'all.
I don't care how much money you were going to pay me. You could throw millions of dollars at me, and I would never, ever get on the stand in a courtroom and defy my science principles, the very core of who I am, and the very principles that I stand for as a human being. I would never defy them so that someone could pay me money and essentially shred my reputation for the rest of my career. Because that's what this is. Make no mistake, this is essentially extortion by Aperture, who must have came to conclude that there was no evidence. And so if you want me to get up on that stand and make a f***ing fool out of myself, like I'm going to have to in order to defend this obscene moron's theory, you gotta pay up, buddy, because who knows when the next time anyone's ever gonna come knocking on my door again will be. But let me be clear. You are not watching this for us to talk about Key Cycles and Trooper Paul, only so it's very clear that this is the man who found, discovered, and began the whole notion that there was a backing event that Karen Reed was responsible for. So that you could see how utterly absurd the basis for Aperture's reports really was. And, of course, there's more, because you might remember this whole exchange with Judge Beverly, the so-called Judge Beverly Cannoni in this case, who went to great lengths to make sure the jury never heard about Trooper Paul and his Key Cycle mishap. However, this theory of his was allowed to stand and put forth by the $650,000 accident reconstructionist company, Aperture. Now, you might note that I'm allowing this exchange between Bob Alessi and Judson Welcher play out for a little while. I'm doing that because I want you to see Judson Welcher's performance.
I didn't buy these shoes for hiking at first. I just wanted something I could wear every day without killing my feet. Turns out they crush it on trails too.
Performance. Because make no mistake about it.
Okay, here we go. I'm back.
The $650,000 price tag was really so that he would put on this very performance that you are seeing right now in front of the jury.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain tax rate events, correct?
Correct.
EDR
Those are my role.
your role, yes. EDR, and just for clarification, EDR is Event Data Report, correct?
Correct.
So I'm going to refer to that that you have before as EDR, Event Data Report.
Sounds good.
EDR data does not show the location associated with
Okay, I'm putting this.
And this particular vehicle is a stop.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a extreme event, correct?
Not at the time of this event.
No, correct?
That is not correct.
So let me ask the question. slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes, that's correct. That's correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify what it is associated with a particular key cycle, correct?
I think I'm going to say yes, but text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so
trigger event, and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So, in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the key text stream event occurred will be wrong. Correct?
It can. I mean, you need to take the totality of the evidence in the text stream, with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again,
What?
and you just
The hell does that
totality
mean?
of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time.
It's a yes or no question, buddy.
Associating that with the wrong infotainment information or vice versa, then that would be wrong.
He can't even answer a yes or no question.
How much time is associated with each trip? There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try the different way. Your analysis or anyone's analysis, any conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. You need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the event. So let's just consider a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location text stream data?
You don't get an incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
So for could go, if Your Honor, we could publish a slide, please, that is the evidence. Thank you.
Slide number.
I got slide 9. Mr. Wolf, replied, yes, the man, I've got the correct slide. Thank you, Your Honor. So, I'm going to use the acronym VCH that you've used on your, you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
I think when I got to, now scroll. So when I got to it, you can see it was at key cycle 1264. Highlight was the last file that was written on key cycle 1167. So to answer your question, I got it at 1264.
So we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Walter, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original votes.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that
Are you saying there's no basis for the question? Yes. All right, now then I'll allow the question.
you are aware that the Commonwealth has maintained up until your engagement in September 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Wilson.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right, and did that, which you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, so I only mentioned 1164, 1165, and 1167. I purposely skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and look at you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been, and also included date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now, to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's
I did. And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it's probably more important that I don't do that to avoid confirmation bias.
But you did read Trooper Paul's report.
Correction.
Damn, I do need to put some more light in here.
Commonwealth is maintained up into your engagement.
I'm gonna see inside behind this.
Isn't that the sidebar that we would
There we
love
go.
to hear? The most important thing for this conversation is understanding that once Judson Welcher gets on the stand, he tries to claim that he had no knowledge. He didn't use Joseph Paul's reports to make his determination, that they came up with this theory about the backing event entirely on their own. The only problem with this, though, is that we now have the receipts. And on these receipts, we see, beyond a shadow of a doubt, the very first thing, and I mean the very first thing, that these guys do is examine carefully Trooper Joseph Paul's reports. Oh, don't we wish the defense team had had these receipts in time for the trial. And what a surprise that they didn't. Hey, is this a discovery violation? Now, there is one more thing that I forgot to highlight. As part of their efforts to try to find evidence on Karen Reed, Aperture insisted on having all of the evidence. That would include the testimony of Nicole Albert and Tristan Morris and Caitlin Albert and Brian Albert Jr. and Julie Nagel and Sarah Levinson. Now, to just highlight how absolutely bizarre this is, imagine one of these two guys are spending hours examining testimony of Sarah Levinson and Brian Albert Jr. in order to determine whether an accident occurred in front of 34 Fairview on the night in question.
The debris that comes off of the tail light, the fragments, what speed would they be going at the point of impact when they crack and are released from the tail light?
At the impact speed or less.
In order to penetrate the sweatshirt and cut the arm across, will the shards have to be going faster or slower than the arm?
They would have to be going faster if they're moving at a common velocity with the arm relative to it. They would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No. You can see here again also the light and the fragments are being propelled forward. And so you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. You know, there was no tag measurements. But if you look at the motion of the tail light, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the tail light fragments have already gone forward and been deposited on the ground. You can, average light speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, it shattered, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest, before he even has a chance to get to where they find him.
I mean, they dug through the testimony the way that we do, trying to find some way to indict Karen Reed of the murder of John O'Keefe. And in the end, they determined for $650,000. Oh yeah, right, by the way, I forgot to mention that in April, Judson Welcher signs a new contract. And this one's for a little bit more than the first one. From Judson Welcher's own admission, there's a very clear reason why he doesn't, in the end, decide to do the kind of testing that we saw with ARCA. You know, the kind with, like, crash test dummies or, like, force and physics. to prove that an accident happened in this case?
Let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test, and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
Oh, really?
I guess just in case you happen to miss the blue paint tests, I'll revisit them.
And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. Me just walking backwards, or actually sideways, into the Lexus. What I've done is I've painted the Lexus right rear tail light with what's called grease paint. Now, sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled in.
This here doesn't mean anything,
With my arm out,
sir.
with the damage.
This here don't mean anything.
So it's from 2 different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed.
Did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the laceration on his arm.
Your assumption, as I understand it, is that Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
And part of the Lexus in reverse, put her foot on the gas pedal and began to press not 25%, not 50%, up to 75% acceleration. It was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe, fell backwards, hit his head.
You can't even prove that.
We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No.
When you were asked to engage in the study, were you ever asked to reach a certain conclusion?
No.
Was there ever any influence other than the data and facts on their analysis?
There's never been influence. The influence, it's whatever the data show.
If when you engage in whatever studies you undertook that you explained to the jury, were you given any direction or limitations on what you could or should do?
No.
When you received the information, did you understand, regardless of the result, that would be provided to everybody?
I guess generally, yes. I mean, I go through the data, I give you the results, you do with them whatever you see fit.
And in this case, when you decided to,
And while all of us were scratching our heads at this blue paint situation, why it was that he was dressed up like John O'Keefe and throwing himself into a car that looked like Karen Reed's? The reason was very simple. It was all he had to plant a seed of possibility. Because in the end, Judson Welcher concedes that there is no evidence. No evidence.
Junk science.
No evidence. So these guys are forced to take Joseph Paul's ridiculous theory and try to use some way to make it make sense, to make it a legitimate theory. And that's what they set out to do. So they bring in, almost as unbelievably as Joseph Paul, Shannon Burgess.
If I did the math correctly, sir, you've been pursuing a Bachelor of Science degree for 17 years, correct? That is correct. And you have not obtained it as you sit here today. That is correct. And yet there are various documents that we've seen that state that you have obtained the Bachelor of Science, correct?
Again, with errors or misinterpretation.
And of course,
This isn't just a wallet, it's a rare find. There's something different about owning something almost nobody else has. That's why when Ridge dropped their limited Kintsugi collection, I had to grab it. Inspired by the Japanese art of turning imperfection.
of course, as soon as the defense gets hold of him, we realize we probably shouldn't give him and his testimony much weight. But let's put that aside, and we'll just pretend, because we're thinking like the O'Keefe family in this case, we're trying to give these people the benefit of the doubt. We'll just pretend that the key cycles are not a problem, and that Shannon Burgess is credible, or even a little bit credible. He's tasked with trying to place Karen Reed's vehicle in front of 34 Fairview at the time and place in question, and he's tasked with trying to make this backing event work, trying to prove that it happens and is responsible for the death of John O'Keefe. The only problem, it's like a small detail, is that in order to do that or even get close to that, number one, they have to pad the numbers.
If a trigger event is one point in time, one snap in time, it would be accurate to say the trigger event is left lasting 5 seconds and ended 5 seconds later. It wouldn't be accurate to say the trigger lasted that long. The event lasts that long, but the trigger is only one point within the event. The recording lasts that long, right? Correct? It captures, or does it, let me ask you this, does it capture 5 seconds before, 5 seconds after that the trigger event is?
Nah, come on now. Come on. Come on, work out. Come on. You still green. Okay, let me rewind it back a little bit, see if it worked. Come on. Come on. Oh, come on now. Give me a second, y'all. Give me a second. Get this thing back working.
course,
There we go.
as soon as the defense gets hold of him, we realize we probably shouldn't give him and his testimony much weight. But let's put that aside, and we'll just pretend, because we're thinking like the O'Keefe family in this case, we're trying to give these people the benefit of the doubt. We'll just pretend that the key cycles are not a problem, and that Shannon Burgess is credible, or even a little bit credible.
Not.
He's tasked with trying to place Karen Reed's vehicle in front of 34 Fairview at the time and place in question, and he's tasked with trying to make this bagging event work, trying to prove that it happens and is responsible for the death of John O'Keefe. The only problem, it's like a small detail, is that in order to do that or even get close to that, number one, they have to pad the numbers.
If a trigger event is one point in time, one snap at a time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later? It wouldn't be accurate to say the trigger lasted. That's my question. The event lasts that long, but the trigger is only one point within the event. The recording lasts that long, right? Correct? Correct. So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle. That's correct. Okay. Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the Aperture reports was referenced off of the end of the event. So of the recording event. So correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
Okay, why did you not correct it?
The Aperture reports was referenced off of the end of the event. So, okay, the recording event. So, correct. Everything on the left-hand side of the slide comes from Mr. Burgess's report. So the 3-second delay was noted in his report. It was noted. Did he apply the 3 seconds in his analysis? He did not. Did he indicate in his report why he ignored that 3-second delay? He did not. When you do apply the 3-second correction, what do you come up with?
Wherever life leads you, should the day come when a medical breakthrough makes all the difference.
It did not. When you do apply the 3-second correction, what do you come up with? And now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
To us, the prosecution put on a good case, and to us, that data from her car and from Johnny's cell phone told the whole story.
Mr. Burgess's original report, I've differentiated the January report. Which did he use to determine his determination of the clock speed? In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2. But he does do the math, which I'll show, for the differences on these phone calls. On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form, and then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times, so that's where I step in and say, if I take that third column that he lays out, those are in seconds. If I apply those seconds, an adjustment to 12:31:43, where do we end up with John's interaction window in those times?
2 more seconds they leave out.
The first report that they put forth
These boys here can't tell time.
knowledge of two of the key Commonwealth witnesses in their case in chief.
Yes, around 12:31, 56 or 57 is the start of the health event, the 36 steps.
The only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into the base of his skull. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
And of course, defense expert Dr. Elizabeth La Posada, one of the most brilliant women in the whole world, confirmed that there was a coup contra coup injury and that John O'Keefe would have been dead almost immediately, within 10 minutes or so from having a crushed skull. So what this meant was that John O'Keefe, after he fell, would have been incapacitated, would not have been able to be up and walking around or using his cell phone because his fine motor skills would have been rendered impossible.
What did you conclude in terms of finishing the work? Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them. Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
And the problem that Burgess and Welcher now have is that every single time that Shannon Burgess puts forth for the time of this backing event happens before John O'Keefe stops walking around and using his phone. And that's even with padding the numbers. So no matter what they do, and
It's officially summer reading season. Allow us at Warby Parker to suggest the perfect...
matter what they do, and including fudging the numbers to try to push them back so that they get closer to Ian Whiffen's time, they still can't get it right. And so, Ian Whiffen testifies on April 28th. And on April 29th, thanks to the note-taking and invoices of Aperture, we see that Shannon Burgess bills for 8 hours to create a supplemental report. And though he tries to claim on the stand that nothing really changed, as it turns out, he changed everything.
The trial starts April 22nd, correct? But the trial is trial about April 22nd. After the trial starts and after witnesses, of course, are hearing, you prepare another report, correct? Correct. And that should be the 8th report. Correct.
And me personally, when it comes down to this trial, I would be aggravated listening to this trial.
It's right.
May 8th, keep that in mind, okay? May 8th report.
Right in the middle of this trial, you enlarged the number for the 21 to 29 range. That's bigger than what's in your first report, correct? No, that is not correct. Oh, you changed the number, don't you? No, I did not change the number. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
All right, so I skipped over a little bit here so that we wouldn't be here all day. What they're talking about here is why did Burgess all of a sudden in the middle of the trial decide to update, quote unquote, or change his report? And in the report itself, it says in the opening paragraph a sentence about, in response to your request, Brennan, this is the report. Okay, so that's what they're talking about here. They're talking about the updated, amended report, the one that he submits on May 8th. And why it is that he submitted that report. Why, all of a sudden, out of nowhere, did you just decide to amend the report? Did Hank Brennan tell you to do that?
Explaining the May 8th report in your language pursuant to your request as a copy and paste from a previous report. Yes, I am. You didn't review it this time, don't you, sir? No. I did not feel significant. Okay, it's significant, sir, that the matter is in the middle of a trial and there's a request for a new report after testimony has occurred in that trial. You don't think that's important? Why did you prepare the new report then?
Sure. So there was a claim from a PowerPoint presentation by Mr. December of trying to adjust clock sweeps or clock adjustments based on the synchronization of certain events. That was produced in March. Upon reviewing that, my initial thoughts were to address that in testimony. But as I was preparing for trial, I made the decision that it needed to be better addressed in a supplemental report.
All right, so thanks to the aperture receipts, we know this is an outright lie. An outright lie. A bold-faced outright lie by Shannon Burgess.
Yep.
So, on April 25th of 2025, Welcher, Brennan, and Burgess all meet to have a discussion, okay? The day after Ian Whiffen testifies, the day after he testifies with the timeline, right? The timeline that states when all of the human interaction with John O'Keefe's cell phone stops at like 12:32 and 20 seconds, something like that. The day after, Shannon Burgess spends 8 hours updating his supplemental report. 4/29/25, digital forensics, time spent writing supplemental report and trial presentation. Okay? But hold on, there's more. May 7th, he spends 5 hours reviewing the supplemental report, and then on May 7th, meeting with attorney and Judd Welcher. Now, it doesn't say who that attorney is. Is that attorney Hank Brennan?
For nearly 50 years, Harbor Freight has been a reliable source for the widest variety of tools at affordable prices. And our tools keep getting better with time. Better performance, better durability, and better value. Whatever you do it for less at Harbor Freight. 10 straight days of incredible deals going on now through October 1st.
So what happens if you're ordered to take a drug test, or you take a drug test voluntarily, and you test positive for THC, but you know you're not smoking it or ingesting it in any way other than through Delta 8, Delta...
Hank Brennan? Or is that their legal team? Somebody for them? But note, it's pretty interesting that every other time when they meet with Brennan, it's written. His name is in there, except for this one on May 7th. Very interesting.
So, do you know the date of Mr. DeSoto's report is March 5th? Does that sound right to you? Yes, that's not so for you.
Remember, this is a bold-faced lie, and we now have actual documented evidence. This guy is perjuring himself. And I guess, you know, it's sad. This is kind of sad, but I guess it's kind of true. It's like if this guy was willing to put himself out there and actually testify in court, lying about his academic background, I guess once a liar, always a liar. And that's a terrible thing to say. I don't want to, you know, make that kind
Terrible
of a general
thing to say.
statement.
But with this guy here, it's
maybe
true.
That's just the way it is. That's the way it is here with Burgess.
So if you hold Mr. DeSoto's report that you claim was the basis for you on your own to this trial, creating and submitting a new report, you claim that the basis for that was Mr. DeSoto's report of March 5th of 2012. That is correct.
It's a total lie. This is a total lie.
Again, my initial thoughts were to address an testimony.
And now Aperture puts forth somehow a range of times, again with padded numbers, to try to get closer to Ian Whiffin's time that John O'Keefe stops using his phone. And even in that case, they produce 9 numbers, and only 2 of those numbers wind up fitting their theory of the case. And in the end, Judson Welcher is paid $650,000 to be an obstructionist, to do everything he can using smoke and mirrors to hide the very painful reality that they have absolutely no evidence that there was a bagging event, that John O'Keefe's injuries came from a car accident, or that these times even add up, in spite what is a noble effort on the part of Aperture to look over every single bit of evidence in this case. In the end, what we are left with is data that ultimately proves John O'Keefe was up and walking around after the proposed bagging event, and that Judson Welcher knows how to dress up like John O'Keefe and put paint on a car that looks like Karen Reed's. There's even an argument to be made here that Judson Welcher and Shannon Burgess did more to bolster the defense's case than they did the Commonwealth's.
Of note, in this angle of the paint transfer test.
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see this.
And this test don't mean anything.
So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video you can't tell where the arm is.
This test don't mean nothing, sir.
Whatever position it's at, you can see as the car backs up here. Look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car, from the angle to the right, of the video on the right, what did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans leans into the car against the light and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow. All of a sudden, shoot in. The surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of pain on the arm, someone would have to stand there, and as the car approached and contacted the arm, they would have to actually push their arm forward and lean into it to get that pain pattern.
Is that, in your view, proper scientific testing?
This is Dave. And it seems like Hank Brennan was a little confused about what his job was here. If he had been playing the role of the defense attorney in this case, trying to plant a doubt or put forth that maybe in some world it could be possible that this was from a car accident, not a dog, and that
David, what you have done here will never be forgotten.
From this day forward, you will join the House of...
possible that this was from a car accident, not a dog, and that possibly
This is totally from dog, bro. What are we talking about?
Karen Reed, because we don't know that these key cycles weren't just a misfire. Okay. Even though the defense witnesses pretty much shut that down completely based on the laws of physics, he fails to remember that in this case, there's that whole pesky beyond a reasonable doubt thing, and that no, you are not playing the role of defense attorney, you are playing the role of the prosecution. And so, of course, this is the very best that the Commonwealth of Massachusetts, to the tune of over $1.4 million, was able to put forth as evidence that Karen Reed committed this crime. And so what does that really say in the end? Well, first it says that they knew that they didn't have any actual evidence to indict Karen Reed.
They never did.
But it also says something much more important that is pretty easy to overlook. And that is, many of us have been asking, why is the prosecutor's office doubling down at every turn? Why won't they let this go, just cut their losses, and run? And there is an answer to that question, and it's very obvious. And the answer is this whole pesky thing that they did egregiously early on in this case, the planting of the taillight. The reason why the prosecutor's office cannot let go of Karen Reed is because in so doing, what they are admitting is that their guys, Massachusetts State Police officers in their office, in the DA's office, okay, the homicide investigators that work directly for Michael Morrissey, planted taillight evidence in this case. How do we know? Because if there is no car accident, which there wasn't, if that backing event does not belong to Karen Reed, which it definitively doesn't, then that taillight is put there by somebody else.
Exactly.
And guess who that would have to have been?
The police
Because
chief.
there's only one group that it could be.
Can
Same group
police?
that deleted videos in this case, hid evidence, inverted videos, edited daylight videos.
Yep.
The same group that 100% by the end of the first day had decided that serious charges were going to be brought against Karen Reed and there were not going to be any other suspects. The same group who wrote out suspects, just wrote them out of the house and completely until they were called out on it by Karen Reed's unbelievable defense team. The same group who proved over and over and over again that they should never, ever have been given a gun and a badge. Not by anyone, not anywhere, not at any place, and not at any time. So this, make no mistake, has always been about self-preservation, and let this be a warning to all of us. This is the power of a corrupt prosecutor's office,
Very
and the
much
lengths
so.
that they will go to try to convict an innocent woman if it means that they themselves will be indicted of a crime instead. Because that is the situation that these people found themselves in that morning. That morning, not to mention that what they were really doing was protecting their own. Protecting Brian Higgins, the ATF agent, and the disgraceful Brian Albert, a long-standing Boston police officer who had a long history of drunken brawling, actually beating up other police officers under the influence, who had essentially a wild animal for a pet that had escaped the yard and injured innocent pedestrians in front of the house before, who was so scary that guests were not allowed to interface with the dog. And the saddest thing about this case, the saddest thing, is that John O'Keefe was a good man, a real police officer, a legit police officer, someone who took an oath and kept it. And unfortunately, these piece of garbage buffoons are so much more interested in protecting themselves than they are of actually seeing justice for the real killers in this case. Now, there is one more detail that I almost forgot to mention. As it turns out, Judson Welcher charged the Commonwealth for the time that he took to fly from California back to Massachusetts. Apparently, he was ostensibly in the building, ready to refute ARCA, to be called back up, as you might remember, after the ARCA witnesses. And then there was this whole incident about x-rays.
Oh, proof. And so proof is somebody looked at it, somebody took an x-ray. I haven't seen any evidence of an x-ray of the arms.
Here we go. Second part.
while to try to understand more thoroughly why it is that some people believe that Karen Read is guilty of the murder of John O'Keefe. Now, I am just a person who likes to understand, and when something baffles my mind, I need to know. And this is one of those things. The truth is, I have no idea why or how somebody could possibly believe that Karen Read is guilty if, in fact, they have been looking at all of the evidence. Now, in that effort, and in particular because of the receipt dump that we got of the last
The
week or
evidence
so
proves that Karen Read was never guilty.
I've been very busy digging through all of the receipts, in particular the ones that came from Aperture. And in the process of digging for that video, digging for content for that video, I came across something that I just wanted to settle. So this is a very short video simply meant to enlighten those who feel as though Karen Read is responsible for deleting the Ring camera video. Now, if you have followed the Karen Read case, you know exactly what I'm talking about. And through the first trial, this really was a point of contention. Even the O'Keefe family felt as though the morning that they found John O'Keefe, they let Karen into the house where she would have been living at the time, so why wouldn't she be allowed in the house? But nonetheless, Paul and Peg, John's mother and brother, were staying at that house, or were at the house that morning, just after they had found out that he had passed. And Karen leaves the hospital with her parents and her brother and goes to the One Meadows address where she had been staying. And she goes inside to the house to see the kids, I guess for one last time, and to get some of her things. Now, her things would have been upstairs in the bedroom, and she's up there for maybe 10-15 minutes just collecting some of her personal belongings. Now, while she's up there, the O'Keefe family made the accusation that she was up there deleting Ring camera footage that would have shown her taillight had been cracked from the night before. Okay, something tells me that wasn't what was on Karen Read's mind at that time. If we sort of go back in time and carefully track what she had been through within the 24 hours that had just preceded that time. But nonetheless, that was the claim, and then there were people on the internet who ran with that.
Why am I deleting these videos? If anything, I mean, I want the video when I arrive home to show that my taillight's intact. I don't know that it would have captured it, but it could have. They wouldn't want that video in because it would show my taillights intact. So who has a greater incentive to delete the video? So who has a greater incentive to delete the video?
Everybody set?
And it wasn't until the second trial that we got 100% clarity, thanks to the very lengthy testimony of Yuri Buchanan. Now, I happen to just have been watching in real time throughout those 3 days that Yuri Buchanan was on the stand. I actually had intended to do kind of a live play-by-play. That didn't happen, but I was watching in real time and recording, and so I remember this moment perfectly. And then when I ran across this video the other day, looking through all the Aperture receipts and looking for content, clips from the testimony from the trials, to be able to highlight some of the points I was trying to make, I figured, you know what, let me just put this out into the world so that we can settle this argument once and for all.
I want to shift gears for a second to One Meadows, if I could, and the video evidence associated with One Meadows. You testified that on direct examination that there there was no video from Ring at around the time 12:36 a.m. When Ms. Reed's SUV returned back to Lynn Meadows. Remember that testimony?
Yes.
You did receive a search warrant return from the Ring Corporation in furtherance of a search warrant executed by Triple Proctor, correct?
Evidence was returned by Ring, yes.
And in addition to the actual video recordings, there was also an activity log that was returned associated with that time, that location from the Ring Corporation, correct?
There was a key log identifying each video that was provided by the time and date when the video was recorded. It's not an activity log per se for the account. It's strictly a key describing the video, telling you what time the video was recorded.
During the entirety of your investigation, was there any evidence uncovered at all that Ms. Reed had access to the account information associated with that account?
No evidence could be provided by Ring documenting that activity.
But there is evidence that someone had access to the account through John O'Keefe's cell phone.
This is Buick. Now. Buick. Exception.
Access to the account through John O'Keefe's cell phone, correct?
I am not aware of that.
Are you aware that after John O'Keefe's cell phone was recovered by Massachusetts State Police, someone at Massachusetts State Police actually opened the Ring app on his cell phone?
Yes.
Who was the person who opened and accessed the Ring app on John O'Keefe's cell phone?
I'm not 100% sure.
What do you mean you're not sure?
Yes. Yes. Sergeant, having looked at this report, is that the first recollection who may have accessed that Ring app?
Yes, that report is authored by Michael Proctor, and it says that investigators accessed the Ring application.
Thank you. I want to show you one other document, if I could. I just handed you what purports to be the search warrant return for the Ring, from the Ring Company, correct?
I gotta take a look for all of that.
Of course. Thank you, Sergeant. Have you had an opportunity to review that document? As it indicated that, in addition to several other files, there is a London session report that was produced by the Ring Corporation as well as highlighted.
Number 4, is highlighted with one Excel file containing login session information.
Make sure I'm very clear about this. Nothing from the Ring Corporation suggested or intimated that Ms. Reed actually accessed any of that Ring account information.
The information provided indicate that.
So you see, for those who still think that it was Karen Reed who deleted videos from the Ring Cloud or Ring app to try to hide her taillight, even the Massachusetts State Police is telling you that there was only one person who had access to those Ring videos, and that person was, of course, Michael Proctor. So, I guess maybe we do have the answer to that question.
Who has a greater incentive to delete the video?
What is that? I'm going to stay on the subject of videos for a second, but shift gears to Ring video footage. You've already kept several hundred Ring videos from One Meadows, from both the facing the driveway and the front door camera, correct?
Yes.
As the case officer, you obtained and controlled those Ring videos from One Meadows from the moment that they came into Massachusetts State Police custody until they were handed over to the company, correct?
Yes, they were archived.
You drafted the search warrant for the Ring video access records, correct?
I did.
You obtained the warrant returns once those search warrants were executed, correct?
I did.
You took possession of Mr. O'Keefe's cell phone, physically, correct?
Yes.
And you had access to Mr. O'Keefe's Ring account in that cell phone, is that right?
Correct.
You indicated that you reviewed several of the videos on his Ring app on his cell phone, is that right?
Yes.
So you obviously had not only possession of his cell phone, you had possession of his login account information to get into the app on his cell phone, is that right?
I don't believe we had the password. We had his email account associated with the Ring.
Which means, some way or another, you could get access to the Ring videos.
Correct.
And watch those Ring videos on his app, on the phone.
Yes.
Which means you had full access to the app. You could keep videos, you could save for later, you could delete videos, you could do anything you wanted to within that app, correct?
Yes, those are the capabilities within that app.
Trooper Proctor, did you delete any of the Ring videos ever from John O'Keefe's phone?
Absolutely not.
Did you delete a video of Mr. Reed arriving to One Meadows at approximately 12:41 a.m. on January 29th, 2022?
Absolutely not.
You will agree, Trooper Proctor, that the video of Miss Reed returning home from 34 Fairview at approximately 12:41 a.m. is not there.
Correct.
As the case officer, you're aware that Trooper Chico also reviewed some or all of those videos, correct?
Yes.
And he did that at your request.
Correct.
He took notes of his review of those videos, correct?
Yes.
And then he provided those notes to you so that you could then memorialize those notes and your notes in a broader report that you then drafted in November of 2022.
Wherever life leads you, should the day come when a medical breakthrough makes all the difference, isn't it clear?
2022, correct?
If memory serves me, the report I wrote regarding the Ring camera was based off my observations of the videos that I had watched.
But you certainly did have, you did accumulate his notes and review his notes as well as your own, correct?
Best of my recollection, I wrote that report off of my notes.
Did you actually, at any point before writing your report, did you note, or did you review his notes?
I can't recall.
You asked him, he reviewed the notes at your directions, correct? At
Yes.
your direction, correct?
Yes.
And obviously he would have wanted to provide you whatever insights he had into his review of those videos. Otherwise, what's the point, right?
Correct.
So when you reviewed his notes, did you see that there were some sticky pads? You remember that?
That sounds about right.
Do you recall exactly, as you sit here, exactly what was on one or more of those sticky pads that you reviewed from Trooper Chico?
I don't know.
Would it refresh your recollection if you would take a look at a copy of those notes?
Yes.
Yes. Yes.
If you would mind taking a look at the top or the uppermost top note that's highlighted with a sticky note next to it.
Okay, sir.
Thank you, Mayor. Coach. Yes. Rocky, do you have these notes in mind, specifically the uppermost note?
The 0041?
Correct.
Yes.
You reviewed this previously before you wrote your report, correct?
Yes.
And you noted that at 0041, which is a time relative to what DeChico was looking at on the ring video, he indicated tail lights from driveway, parentheses, I think she arrived home, in parentheses, correct?
Correct.
0041 is what? What's that in reference to?
Just after midnight, the approximate time where Miss Reed will be returning from Fairview Road.
It's military time for 12:41 a.m., correct?
Yes.
You wrote a report on November, I'm sorry, I earlier said November, it's actually June 1, 2022, memorializing the times that were of note to you in that ring footage, correct?
Yes.
Do you recall every single entry that you made concerning the events that were of note to you that were reflected in your report?
The majority of every single one.
Would it refresh your recollection to look at a copy of your report to determine what all you did and did not note?
Yes, sir.
Sure. Do you have it with you, Trooper? Do you have your report with you? This is me interrupting your programming to remind you to like this video.
Be back in a second.
I'd ask you to review that report, especially as it's in page 2 and 3. Yes. Trooper, do you have those events in mind?
I do.
Your report is dated June 1st, 2022, correct?
Correct.
And reflected in this report are the bullet points of the times that you found of some note in your review of all of the ring footage from One Meadows, correct?
Yes.
In your report, there is no mention of the footage showing Karen Reed arriving home at 12:41 a.m., correct?
Correct.
And that's notwithstanding the fact that in Chico's report, his handwritten notes, he makes note of an event at 12:41 a.m. indicating, I think she arrived home, correct?
Correct.
So, sometime between when Trooper Chico wrote his notes and when you wrote your report, that video footage vanished.
There's also no date on Trooper DeChico's notes. We have many dates for ring video, so I don't know if he's referencing a different date.
You want diamond earrings with a hefty price tag? Let me show you how. These stunning 14K white gold lab-grown diamonds are just $399.99. You get that high-end luxury vibe without emptying your entire wallet. Plus, lab-grown diamonds are pretty much identical to mined ones, except for a fraction of the price. So you get all the sparkle for less. At under $400, these are the perfect gift for any occasion. Whether it's a birthday, an anniversary, or just a treat yourself moment, these studs are timeless. As if that wasn't enough, they've got free 2-day shipping and a 30-day return policy, so you're covered no matter what. No stress. And with a lifetime warranty, these are built to last.
People with blood cancer want more time to do the things they love. That means more time to be movie buffs. At Jazz Collectors, we are Blood Cancer United. We do the most for more people with blood cancer so they can do more of whatever they want. Join us and donate today.
With a different date.
Well, you're aware that the video footage from 12:41 a.m. is gone, correct?
Yes, it's something I've tried to find through Ring for months, as well as the video when Miss Robbins, Miss McCabe, Miss Reed arrived back at John's and they're looking at the broken taillight. That video is gone as well.
So, At some point, while this footage was in Massachusetts State Police custody and being reviewed by Trooper DeChico, that video existed.
Objection.
The objection is sustained. Comes in super handy to have the judge in your pocket. Mr. Jackson, don't waive that again, okay?
The fact is, notwithstanding Trooper DeChico's handwritten notes, there's no video of 1241 and January 29th, is there?
No, there isn't.
Seems pretty clear to me who had more of an incentive to delete those videos after all. Just when you thought you were out, pull you back in.
From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute.
I am pinching myself to make sure that I am awake and not in some ridiculous, disgraceful delusion.
Go ahead, State of Commonwealth, Massachusetts.
Yes, that's right. Know what words to use for what's happening here. The only thing I can come up with is asinine, insane, absurd, and the fact that we are doing this again is
Damn it, hold on. I did not mean to do that.
unimaginable. What is going on?
I'm back.
Okay, so huge day today if you have any interest in seeking justice for John O'Keefe because of two simultaneously significant events. First, Karen Reed and her defense team unleash a bombshell.
As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are issued in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights, conspiracy, the claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins.
And most definitely McCabe.
On the 19th question, those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Kenton through its police department for negligent failure to secure the garage and the sailing port. We're asking the court's permission to bring those claims into the
binge watching television, so I said, let me go back to school. I have a son.
Given the voluminous nature of this case,
Then we had to sit through this.
Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically in 1 to 2 hours before JJ's body is ever found. Anybody knows his whereabouts. Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family
Okay, I'm back.
sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not
Why is they so mad at Turtle Boy? Only thing Turtle Boy did was expose the truth about y'all.
and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute.
And the fact that we have to sit through this absolute ludicrousy once again is so unimaginable. It is hard to believe that this is really happening. But okay, if you want to do this for yourselves, okay. No problem. We'll do this again. Sure. Why not? Okay. So be it. But here's what I can promise. If I were the plaintiff in this case, I would definitely not want to be going up against this.
Good afternoon, Your Honor. Damon Saxon on behalf of the defendant, Karen Reed. Good afternoon, Your Honor. Charles Waters for defendant Karen Reed. Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed. Good afternoon. Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed. Good afternoon. Good afternoon, Your Honor. William County on behalf of
5 damn lawyers. Women 6? 7? 7 lawyers?
Just in case you forgot, because it's been a whole 15 minutes.
Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder
I would remind you of the evidence in this case. Now, let's start with these claims that Karen Reed intentionally, knowingly, because of some intentional plot and plan to try to get one over on Kaylee, caused her some type of emotional harm. In case you missed it, you might want to think about the 50-plus phone calls that Karen Reed made in between 12:30 a.m. on the morning of January 29th, 2022, and when she stumbled upon the already very dead body of John O'Keefe.
South Carolina residents have less than 24 hours left to do something that could save them thousands of dollars. If you live in the state and are a resident here, you can now officially apply to have your...
She stumbled upon the already very dead body of John O'Keefe.
44-year-old murder defendant made 53 calls to O'Keefe's cell phone between 12:37 a.m. and 6:08 a.m.
Trevor Nicholas Garino, G-U-A-R-I-N-O. 24 a.m., the defendant calls John. Voicemail number 3 is left with voice.
John, I'm killing you fucking kid. Nobody knows what the fuck you want to fucking voice in the morning. I'll get what you need to F you. You fucking pervert. You're a fucking pervert.
At 1:10:44 a.m., the defendant calls John. It's not answered. At 1:12:18 a.m., the defendant calls John. It's not answered. 1:12:46 a.m., the defendant calls John. It's not answered. 1:13:13 a.m., the defendant calls John. Not answered. At 1:14:11 a.m., the defendant calls John. It's not answered. 1:14:44 a.m., the defendant calls John. Not answered. 1:16:10 a.m., the defendant calls John. Not answered. 1:16:38 a.m., the defendant calls John. Not answered. At 1:17:37 a.m., the defendant calls John. So with voicemail 6 is left with voice.
John, I'm going home. I cannot wait to go home. You are fucking
At 1:18:38 a.m., the defendant calls John. Not answered. At 4:38:14 a.m., the defendant calls John. Not answered. 4:38:49 a.m., the defendant calls John. Not answered. 4:39:39 a.m., the defendant calls John. Not answered. 4:40:05 a.m., the defendant calls John. Not answered. 4:42:54 a.m., the defendant calls John. Not answered. 4:45:10 a.m., the defendant calls John. Not answered.
At 4:53, my phone rings, and I look at my caller ID. I look at the phone, and it's Kaylee. John's niece. John's niece.
When you pick up the phone, did you hear a voice on the other end?
I heard a voice and a lot of screaming.
And the voice you heard, was that Kaylee, John's niece?
Yes,
And the screaming, was it a man or a woman screaming?
it was a woman.
How loud was that person screaming?
Very loud.
Could you make out anything that person was saying as they were screaming?
My name screamed a lot. And then the other individual ended up getting on the phone with me.
And who's that person that was screaming in the background?
Miss Reed.
How long was she screaming for while you were speaking to your niece before you spoke to her?
The entire time I was speaking to Kaylee, she was screaming.
Describe her demeanor.
Miss Reed's. John! And she's screaming that John didn't come home. She left him at the waterfall. She was hysterical. I was very hard to follow what she was saying.
What was the reason that you woke up?
I got a phone call at 5 o'clock in the morning from Karen Reed. Karen called and the first thing she said was, Carrie, John's dead. And then she hung up.
She was yelling loud enough my name. I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
5:04:27 a.m. The defendant calls John, not answered. 5:21:28 a.m. The defendant calls John, not answered. 5:21:58 a.m. The defendant calls John, not answered.
Karen showed up at my house.
How did you know Karen showed up at your house?
I could hear her screaming out front.
What time is this?
Approximately 5:20. I can't be sure.
5:23:26 a.m. The defendant calls John. Voicemail number 7 is left with voice.
Let's kill him.
5:23:26 a.m. The defendant calls John. Voicemail number 7 is left with voice.
Let's kill him.
Right, because that's the voice of a cold-blooded murderer.
At 5:24:27 a.m., the defendant calls John, not answered. 5:25:28 a.m., the defendant calls John, not answered. 5:26:14 a.m., the defendant calls John, not answered. 5:28:16 a.m., the defendant calls John, not answered. 5:28:43 a.m., the defendant calls John, not answered. 5:29:21 a.m., the defendant calls John, not answered. 5:29:46 a.m., the defendant calls John, not answered. 5:30:15 a.m., the defendant calls John, not answered. 5:30:52 a.m., the defendant calls John, not answered. 5:31:21 a.m., the defendant calls John, not answered. 5:36:29 a.m., the defendant calls John, not answered.
They drive to the house where Karen dropped John off. It's dark in a blinding blizzard.
It was so snowy, you couldn't see it. As we were driving, Karen was leaning between us. She was frantic. I mean, she knew John was missing, so she was frantic about it, as I would be. And then we turned to pull down Fairview, and she saw him on the lawn.
6:03:02 a.m., the defendant calls John, and voicemail number 8 is left with some voice and noise in background.
Miss Gillen, can you play that, please?
Carrie quickly joins Karen on the lawn. The two women perform CPR on John until police arrive.
I saw Miss Reed. Looked like she was giving CPR to him, and she had blood on her face.
Karen Reed and 2 other women were huddled over him. Seconds later, dash cam video shows jurors of frantic Reed running back and forth in front of the police cruiser.
Miss Reed was visibly upset.
What's the environment that's going on around you?
Karen's just running around crazy, like just yelling, screaming, kind of confused.
Because I will tell you this, there is no world for a legitimate mental health professional that is not being paid off by, I don't know, the O'Keefe family or the Commonwealth or God knows who, for God knows what reason, would not sign off on Karen Reed not being completely out of her mind, teetering on psychosis on this morning.
I tried to comfort Miss Reed. At one point, Miss Reed was very upset, and one of the officers thought it would be best if maybe she went just out in one of the cruisers for a little bit. She was just doing a lot of screaming and yelling, and I think they were just trying to, work on John and see it a little less chaotic.
And when you listen to those statements, did you hear any of them talk about the idea or issue of coercive attack?
Yes.
And when you listen to those statements after you formed your opinions, did in any way, change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because the defendant had a very stressful event. Finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction.
very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many times in the emergency department.
So I went into the back of the car with her, and Carrie Roberts came over. And then we all just sat in the back of the, Karen and I kind of were scrunched and sitting in the back, and Carrie was at the door of the cruiser.
Why did you get in the car?
She was crying. She asked me to get in. We held hands. We prayed. She did have blood on her hands, and she said, could I have gotten my period? Who's going to take care of the kids? She just kind of was all over the place. And then at one point, we saw them moving John towards the ambulance. And at that point, Miss Reed started yelling to Miss Roberts, go check on him, are they working on him? Is he dead? Is he dead? And at that point, myself and Miss Reed got out of the car, and she started yelling and pulling on me to Google hypothermia, and to Google how long it takes for somebody, to die in the cold.
Where was Jen McCabe exactly at this time again? I don't remember. Where did she say they were? Well, let's go have a look.
Family court is if you have a contested case, especially
I don't remember. Where did she say they were? Well, let's go have a look.
I have access to the source code, correct? So with your opinion, oftentimes, with regard to ultimate conclusion, based on research and testing.
So let's hear what Sergio Gennaro has to say about
Okay,
Jennifer
well, what's
McCabe's
that?
infamous Google search.
She says, again, I'm not sure about the exact times, just Karen asked me to do it. So, again, we're still right inside of her head here, which is right where we want to be. And you're aware, Ms. McCabe, that both spellings of that phrase result in the exact same search results, don't they? I'm not aware of that. That is really interesting. I'm going to highlight that. This is a true statement. So now we have to ask why. It almost throws me off to see a true statement from her. So we don't want to ignore that. So he says you're aware that both spellings create the exact same search results. And if she's not aware of that, it means that she didn't look at the results. So why would she not look at the results? Because she didn't care. She's Googling it for a different reason. So my question to you is, why the two searches? What do you think about that? Okay, she was standing next to me screaming, shaking my hand. My hand was cold. I was trying to Google it. Obviously, maybe, whatever came up first didn't make sense because I had some misspellings, so I did it again. This is a completely rehearsed statement. So that's a long way of saying this is an indicator of deception here. So, how long to die in cold result in articles concerning time of exposure? And she says, we never got the chance to read it. But this is what's important here. This use of the word we, she does not see Karen Reed as a friend. So, for her to say the word we here, this is wildly and crazily out of place. In my mind, this is just screaming there's not just deception, but there's a big problem here that needs to be looked at. My note here is that she wasn't with Karen when this happened. And you see, even Mr. Jackson picks up on this. He says,
Okay,
well,
who's we?
Wait, when you say we, who's we?
Yeah.
It even stands out to him. So,
Yeah, who?
if I had any say in it,
Who's
I would
we?
go back and review the GPS from everyone's phones. I would look at pictures, videos, and try to determine who Jennifer McCabe was actually standing next to at 6:23, 6:24 a.m. She is working with somebody to try and fix the mistake on her part of Googling at 2:27 in the morning how long it takes to die from exposure. Someone is standing next to her right here trying to help her cover that up.
Jennifer McCabe, controlling the narrative. At 6:23 a.m. Look at where Jennifer McCabe is and what she is doing. She calls Brian
to Your Honor, JJ is involved in a relationship with Miss Reed. Time at that time, January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ. She leaves him to and Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home.
And I will draw your attention to Hank Brennan in this case. And Hank Brennan, very expensive witness that the people, the taxpayers of the Commonwealth of Massachusetts paid for, who told us that John O'Keefe would have been dead from a fall very quickly.
Well, as he fell backwards and he struck his head, he was clearly at a very high
Here we go. Combat.
generated by the gravity. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
So whether you support the Commonwealth or the defense in this case, there is no world, not a single place on the planet where John O'Keefe could have been saved by a medical intervention, because I will remind you of this.
The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain. And the brain is round around, therefore within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain. It causes small little hemorrhages, and it causes the brain to swell. If you get an injury on your arm, it starts to swell. The same thing happens when that energy is applied to the brain. The brain starts to swell.
So in other words, he was having bleeding on the brain. That's what you're telling us. Yes?
Unfortunately, the brain, when it swells, it doesn't have anywhere to go. It's because this is encased in the skull. So what happens
Okay,
is
yeah,
the brain starts
bleeding on the brain.
under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem to control the heartbeat and breathing, and that's called brain stem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
So no, John O'Keefe was not left to die in the cold, but thanks to Jennifer McCabe's 911 call, we already know that John was dead. And the only way that she could have possibly known that was if she was with him when it happened. Listen for yourself. How many times does Jen McCabe say John is dead in this call? See if you can count that.
Acting weird.
We know for sure that Ms. McCabe knew.
Sure show hell
We also
did.
know from Brian Higgins' testimony where he gives it away that he knew John O'Keefe was dead.
You're a former military guy, right?
I am.
Okay. 1 o'clock, 1 o'clock up on a watch. 12 o'clock is due north, or right in front of you. 1 o'clock is just a few degrees to the right, correct? That's what you meant.
At 1 o'clock, yes.
So, you didn't see a body when you got in the Jeep.
No, I did not.
Then you turned the engine on, correct?
And the wipers, yes.
And the lights.
Yes.
And the lights lit up everything in front of you, correct?
Yes.
You still didn't see a body, did you?
No, I did not.
Sitting in the driver's seat, you put the car in gear and began to roll forward, right?
Yes.
But there was a plow on the ground. It scraped for a foot, right?
Yes.
So you picked it back up,
Yes.
looked out the windshield to make sure the plow was situated, and continued to roll forward, correct?
I knew it was up, but I continued to drive.
And as you continue to drive, you're looking ahead of you and probably to your left to make sure that there's no oncoming cars, right?
Well, I knew there was no oncoming cars. I was just driving forward.
Right. So your focus is directly in front of you.
On the road, yes.
And everything in your peripheral vision is right in front of you as well, correct?
Yes.
Nothing obstructing your view.
I mean, other than snow on the car.
Nothing obstructing your view outside, toward the lawn. Wasn't another car parked there.
No, I didn't. There was no vehicles in front of me, no.
Sorry. Oh, hey, team. I didn't even know you was there. Oh, Lord, that was an hour ago. I'm sorry, 18.
As you drive past that flagpole, everything lit up, and everything in your peripheral vision. You still didn't see a body on that lawn, did you?
I did not.
Dang, I didn't even know 18 was in here.
Is that right?
I'm so sorry, 18.
First responder.
Yes.
And you're currently a law enforcement officer.
Yes.
That puts you in the position of being a first responder, correct?
I'm also a tactical medic, yes.
Which means that you have training to be an observer. You're a trained observer, more than the average person, correct?
Yes.
You look for things out of the ordinary. You look for things that don't belong. As an investigator, former firefighter, first responder, correct?
Yes.
And you did not see a 217-pound man bleeding out on the side of the road in the lawn or in the yard, just to your right by that flagpole, correct?
If I did,
I didn't
I
ask
would have
you
done
if you
something
did.
to help him.
I asked you if you saw one.
No, I did not.
And that's because there was no body there, correct?
I didn't see anything.
Because if there was a body there, you certainly would have seen it.
Objection.
Almost immediately, and that he tried to do everything he could to save his life. And then we also hear from Brian Albert, who tells us so passionately that he would have taken a bullet for John O'Keefe.
Why didn't you just go outside and investigate or take a look?
I'm not a Canton police officer. I'm a Boston police officer. I was just woken up out of a cold sleep from hanging out the night before. By the time I came downstairs, the police were already in my house. John was already gone. There was nobody to save. I would have taken a bullet for John O'Keefe.
That leads us to believe that it may have been an accident. Whatever happened in and around 34th Fairview on that night may very well have been an accident. Most likely a brawl that went too far.
We know the attack took place in the garage, and we know how John O'Keefe died.
There was clearly evidence of a structure that was absolutely 100% consistent. Is 100% consistent.
With the gash on the back of the head.
The gash on the back of his head.
And the structure was...
A ledge. A concrete ledge. You stepped down a 4-inch ledge.
Also say he has a pattern head around the back of his scalp, where there is a tearing in the scalp, and then vertically above that, there's some hairs of scraping to the skin.
Most likely involved a large German Shepherd named Chloe, who just happened to live in the house. But one thing is for absolutely certain. Karen Reed never backed up into John O'Keefe. And whether the O'Keefe family and their very misguided friends want to try to put forth an absurd theory about cell phones and telematics and car data, which never added up, not for a single second. And don't forget that the people that put forth that idea to begin with were either this guy.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
It's me.
Me, the roll me.
This is Buick. Now.
We're almost done, y'all. Hold on.
Anything from this collision? Me, the roll me.
Or a group that was paid approximately $700,000 of taxpayer money to make that statement.
You stated on your direct examination, I have no dog in this fight, correct? On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was similar to the work of Truman, correct?
I have no idea. I don't get the billing statements.
Whether Aperture is working for free in this matter.
No, I don't believe that. You're an engineering company, no for a time.
So we know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid. I don't know that.
Sir, you are a senior vice president of Aperture, yeah? I know. You would know, wouldn't you, if your firm was not being paid for work since September 23rd of 2024?
No, probably not.
So is your testimony you have no knowledge about any contractual relationship between Aperture and Commonwealth?
Well, no, I was sent a contract with Commonwealth, signed, so I'm aware of the contractual agreement. But the day-to-day or month-to-month invoicing and billing, I'm not involved with.
Idiot.
And if it had been Karen Reed driving the Lexus that night, which it wasn't, John O'Keefe's injuries did not come from a car.
Exactly.
That then, of course,
Them injuries did not come from a car. Ain't in no way or no form.
In front of us, Massachusetts State Police, namely Brian Tully, Yuri Buchanan, and Michael Proctor, former trooper Michael Proctor, planted taillight evidence in front of the house. And how do we know that? Because John O'Keefe was never hit by a car. That leaves only one possibility, because that is who took possession of Karen Reed's vehicle.
And where did Sergeant Buchanan go?
We followed the tow truck from the address in Dayton to the Canton Police Department. We're secured in the Sallyport Bay.
And you originally claimed that that seizure took place at 5:30 p.m. Is that right?
Correct.
You signed numerous affidavits under oath, claiming that you did not seize Mr. Reed's vehicle until 5:30 p.m. on January 29, 2022. vehicle, you were unaware that there was alarm.com surveillance footage of the area from which the car was seized.
Correct.
The fact of the matter is, that was false. The car was not seized at 5:30, was it?
4:16 p.m.
Right. An hour and change, an hour and 18 minutes, an hour and 20 minutes earlier. Is that right?
Yes.
Did you ever seek to change or amend the error, false statement about the time? So, or seized any of those documents that you filed under oath?
When I incorrectly transcribed the times, it was on the first affidavit I had written. And then as I continued to write other search warrants, I used that as a template. So I never caught it on the first one, and that's the reason those times are off.
And look at Karen Reed one bust out laughing.
So the first one was false, and then every single one after that was false too.
It was just an incorrect transcription of time.
An incorrect transcription of the time.
Yes.
Call that, I don't know, Smith's error?
Objection.
Ask it differently. Sure. Is it a typo?
Yes.
It was a typo. So you got the 4 wrong, you got the 1 wrong, and you got the 6 wrong. And those turned into 5, and 3, and 0. Right?
They were typos, sir.
And with reference to the Canton Police Department's Sally Port Garage, why was the vehicle taken back?
I wasn't part of that decision, but it's my understanding that it was a heated facility. The other options were, I believe, the barracks in Milton, but that's not large enough to house a vehicle that size, and it's not heated.
Okay. The fact of the matter is, you delivered that car to Canton PD to the Sally Port Garage before a single piece of taillight material was ever found in this case. Trooper Proctor, is that correct?
Correct. It arrives at 5:31.
And you also took it to the Canton Police Department because that was close.
That was not my decision.
Whose decision was it?
I don't recall. I know that
You're the case officer.
I would.
Who decides?
It wasn't my decision. I did not make that call, sir.
So who are we pointing the finger at? Was it Sergeant Buchanan?
Objection.
Ask it differently. Sure. Was it Sergeant Buchanan who made that decision to transport it to Canton?
It's a supervisor's decision. I don't know who it came from.
Was it Lieutenant Tully?
Again, I don't know who it came from. Yes.
But you better know those facts. I don't know about y'all, but after watching this today, I walked away feeling like I've had enough of this. What the are we doing? But you know what? This is how we're gonna get to the truth. So for those of us that care deeply to find out what happened to John O'Keefe and to see justice for him be done once and for all, it is through these trials, story that is produced from them and by them, just like how the Commonwealth has insisted upon going after Aidan Carney, which results in all this discovery, all these emails, and somebody as amazing as Mark Federow and Timothy Bradle and Olivia Lamb coming together to lay out exactly what has happened
Yep.
in that case to try to shut up Turtle Boy for outing the very people that went after him for their criminal behavior. And yes, I said criminal. And whether it's negligence or criminal intent or both, it's for in the exact same way It is the exact same circumstances in the exact same way that we are going to get at what really happened here, and it will very likely, when all is said and done, result in bringing the real murderers of John O'Keefe to justice, regardless of what the O'Keefe family wants to believe. And my heart goes out to them. It truly does. They should never have had to go through this. It's a tragedy that the Massachusetts State Police and the local Canton Police Department misled them into believing that Karen Reed was responsible for this, but that is exactly what happened, and shame on them. It is not enough for Tully and Yuri McKennick and Michael Proctor to just not be police anymore. These guys should be brought up on charges, as should the district attorney, Michael Morrissey. And I understand that's not so easy to do. These people are criminal and corrupt, and they need to pay for it. So you guys want to go after Karen Reed? Go for it. Go after her. But I think it's pretty clear that is going to be maybe the single biggest mistake you will ever make.
And we are done. Like, share, subscribe. I thank y'all for rocking with me. See y'all later. Peace.